Hello, everyone. Good evening. How are you all doing today? My name is Attorney Ifeoma Odunlami. I am an immigration attorney from the Odunlami Law firm here in New Jersey, and I'm so excited to join you guys on live today. I haven't done a live in a couple of weeks. Uh, I was out last week for Memorial Day and another additional day, and of course, I've been swamped this week at work, but I have missed you guys, and I'm excited to give you this topic. So, call friends and let's dive in, okay? So, if you're joining me for the first time, please let me know it's your first time and say hello on the comment section. Hi, everyone. Hi, Proxy. Good evening, AZ Guy. And yeah, so let's get started. So, guys, I had this consultation. Somebody called my office, and I thought, this is a question I get all the time. So this is a good time to discuss it. Put some minds at ease, and um, hopefully, be able to assist you guys. So, this person, the question they had to ask was, let me give you the background. First of all, this person is a green card holder, a conditional green card holder, which means that they have a 2-year green card, right? It's temporary. They have to remove the conditions, and apparently they've had a green card for like a year or so, and they and their spouse are no longer getting along, and the spouse is threatening to call USCIS and have him deported. And the pressing question that he gave me was, can my US citizen spouse, it could be an LPR as well, but for the purpose of this story, his question was, can my US citizen spouse get me deported? And the answer is no, 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 no. Too late for that. Your US citizen spouse does not have the power to ask that your green card be taken away from you. They don't. So if you know somebody who has this issue and who's so worried about this, forward this video to them. And I'm going to talk about, this conditional green card, what that person can do in this situation, because there are ways that you can, take care of getting your own permanent green card, your 10-year green card, without having to ask your spouse to jointly remove it. Because this spouse who's threatening to contact USCIS to get your green card revoked is not going to jointly try to remove the conditions. So you're going to have to do it on your own. And this is how. Let me start from the beginning. Let's talk about the conditional green card. And if you're just joining me, this is a question that was asked, and this is the answer, and I'm going to go into it in a little detail. So the question is, if I have a green card, temporary green card, or even permanent green card, can my US citizen or legal permanent resident spouse contact USCIS and have my green card revoked? And the answer is no. No, no. So you all know that if you're married to a US citizen and a green card holder, and you get your green card, you receive your green card within 2 years of your marriage to that US citizen or green card holder, you're going to get a temporary green card. It's a 2-year green card, and you have to remove the conditions on the green card within 90 days of the expiration of the green card, right? Now, remember, the form to use is a form I-751, not the form I-90, which is a form to renew your green card if you need to renew it. It's been 10 years, or if you need to change some information on the green card, or you lost the green card. So for the purpose of removing the conditions on your green card, you're using a form I-751. So typically, you're supposed to remove it with your spouse jointly, right? Your spouse is supposed to jointly petition with you to remove your green card. And so when you file the form I-751, you have to send in evidence showing that it was a bona fide marriage, and you're looking to add evidence, especially showing that the marriage, you guys continue to be in marital union, you continue to, live together and do things together as, as a couple, even after you got your green card. Because a lot of times before you get your green card, you may not have a lot of documentation. But once you've gotten your green card, you can work, you can file taxes, you can open accounts. There's really no excuse to say, oh, we couldn't commingle our finances because I didn't have this, I didn't have a social. That's not going to come into play. And so when you submit this, you're looking to submit additional information. Don't just regurgitate the same thing you submitted to get the green card. You want to submit additional information. However, sometimes the relationship doesn't work, right? And in this case with this person, they had actually filed a joint removal together. So the question is, well, we filed a removal jointly. What do I do? Well, the thing is this: if you file to remove the conditions jointly and your spouse and you are not together anymore, you're going to have to look for one of the 4 waivers to go on your own to get your green card, because a jointly filed petition means that your spouse, if called for an interview, has to go with you for the interview. And if your spouse is not interested in going with you for the interview, that's going to be a problem. So what I tell people is there are 4 waivers. Figure out which one is going to work for you so that you can self-petition and remove the conditions on your green card. A lot of people are afraid to get divorced. Oh, my spouse says they want to divorce me. Should I divorce them? Is it going to affect my green card? No, file the divorce already. Like, if your spouse wants to divorce you and you are not interested in marriage and you guys have decided it's not going to work, don't, because you're trying to get your green card, stay in that relationship. Because if you file a divorce, you can use the divorce waiver, right? And guess the thing is this: if you file the divorce waiver, you don't even have to wait until the expiration of your green card. As soon as the divorce is through, go ahead, submit your I-751 and check off that the reason you're submitting this is because you're no longer together with the US citizen or green card holder, you're now divorced. And then you must also include proof that it was a bona fide marriage. That requirement does not go away. USCIS wants to make sure you didn't get your green card in a sham marriage. And I'm going to tell you this, you guys, I-751 is tough. If you need to remove your conditions, please go to a reputable attorney. Don't even try to do it yourself, because a lot of times USCIS wants to check to see if they made the decision the first time the right way. Did they give you that green card properly? So they're going to be looking to make sure that they're going to go back to see whether it was a bona fide marriage. And a lot of times we've seen, especially in this Biden administration in the past 2 years, we're getting green cards approved without an interview. Let me tell you now, they're back to interviewing. So if you got your green card without an interview, expect to be called for an interview. Don't mess around with that I-751. It's serious business. All right. So in the case of this person who is in an abusive relationship, because I gathered it was abusive based on the conversation we had, right? They can also use the waiver of physical abuse or extreme cruelty. Now, physical abuse means some form of battery. Maybe the person was hitting them. And extreme cruelty does not require it to be physical. Extreme cruelty can be psychological. It can be verbal. It can be financial abuse. It can be what else? Sexual abuse is a form of physical abuse, actually. It can be psychological abuse. So is your spouse treating you in a really bad way? Are they cruel to you? Extreme cruelty, right? Do they make you feel really bad because of one thing they're doing, or a combination of little microaggressions together, they're just driving you crazy, right? So if that's the case, you can also, if you filed already on a joint petition, you can actually tell USCIS, write them and tell them that you're updating your filing from a joint filing to one using the waiver of extreme cruelty or physical abuse. And get this, once you do that, right, make sure you have your evidence, submit all that, submit a declaration explaining what you've been through. Once you've done that, USCIS will create a new receipt number, and they will begin to apply the safe address handling procedure to your case, which means this is now confidential, right? They're not going to discuss your filing with your spouse. They're not discussing your filing with anybody. It's now confidential because of the allegations of abuse. And they're not going to take anything that your spouse says as evidence against your case. That's the law. All right. Thank you, Danny Blackman. He says, also love how you explain everything. Thank you. So honestly, guys, don't live in fear. Live in knowledge. Live in knowledge. Know what you can do. Know what your rights are. And so once you file on a waiver, your spouse is no longer in the picture, right? You now have to show that your marriage was bona fide, because like I said, that doesn't go away. You still have to show it was a bona fide marriage, either when you're using the divorce waiver or you're using the extreme cruelty or physical abuse waiver. You still have to show it was a bona fide marriage. And how do we define a bona fide marriage? At the inception, when you got married, your intention was a good faith marriage. You got married in good faith. Now, the fact that the marriage didn't work out is not relevant to the fact that it was a good faith marriage, but you have to show that it was a good faith marriage, okay? And so when you're using the exceptions or the waivers, right, you must establish that it was a bona fide marriage, all right? And so there are two other waivers that you can use. You can use a waiver of death. If the U.S. citizen or green card holder spouse passes away, you can use the waiver of death because they're not available anymore. But remember, you must file within 2 years of the death of the person. Same with the divorce waiver. And then the last waiver, which is the extreme hardship. For this waiver, you don't need to show a bona fide marriage. You just need to show that within the conditional residency period, you would suffer extreme hardship, or something happened that will cause you extreme hardship if you had to be returned to your country, if you had to be kicked out of the United States, right? So somebody says, how do you show it was a bona fide marriage? So how do you show it's a bona fide marriage? It's providing proof of your life together, showing that you entered into the marriage, to be together. USCIS loves financial commingling because they feel that all couples should just put their monies together, even regardless of the fact that some couples don't want to do that because they don't want to fight about money, because money is one of the big reasons for conflict. But I always say it's the totality of your evidence, because sometimes some people don't have one, but they have the other. So for instance, if you have a lease, fantastic. If you have a mortgage, fantastic. If you have a lease and your spouse is not on the lease, because maybe the landlord was like, you don't have papers, I'm not putting you on the lease, every landlord can put your spouse as somebody who's authorized to live in the house, right? So they like that. Now, sometimes people can afford to rent an apartment on their own, or they can afford to buy a house or whatever, and they're living with somebody. That person can write an affidavit saying, they live with me, this is how much they pay me, or maybe they're not paying me anything. You can get affidavits from the neighbors, people who can ascertain to the fact that you guys are living together in this residence. But sometimes you don't live together because of one reason or the other. Then in that case, you want to show that you're visiting each other, whenever it is that you're going to see them. You have text messages, you're texting each other, you're calling each other, you're together, and you have to explain why you're not living together. Because sometimes there's a reason why you're not living together. Maybe somebody has a great job somewhere and you're still waiting for the other partner to get their green card or to get another job, or maybe the other partner is a student and cannot leave until they graduate. So there are many reasons. The thing is, you have to speak your truth. You have to explain. Don't assume that USCIS is going to understand because you put a couple of bank statements. No, you have to really make it easy for them to go through your evidence and see a slice of your life. Now, talking about bank bank statements, they like that too. But they don't want bank statements that don't have any activity, because it doesn't show that both of you are using the bank statement. They want bank statements that show that it's being used for stuff. You have what you may call it, bills being paid through it, or the debit card, your debit cards are using this account, or your pay stubs are going into the bank statement, right? Sorry, the bank account. What else do they like? Let's see. They like to see pictures. They like to see things showing that you're doing things together. You're presenting yourself as a couple to the outside world. You're going on vacation. If you're going on vacation, you want to show proof that, either maybe you have a hotel receipt or air flight or train or whatever it is, or you're going to watch shows together, whatever it is. Your regular life, right? You can show them what your regular life is. And I'm not telling you guys to run up a bill trying to travel and do all that stuff if that's not what you do. But whatever it is you're doing, make sure that you can document it and you can show that. And remember, another thing is, when you come for that interview, USCIS is going to interview you and your spouse to make sure that, unless you're doing the waiver, to make sure that your statements are the same. But when you're doing a waiver, right? Let me stick to the I-751. When you're doing the I-751 waiver and it's just you, your spouse is not going to be there. So they're going to be looking at what you've presented. They're going to be asking you questions, and they're basically sometimes going to verify what you say with other information that they have. They can do a fraud investigation after your interview and go ask people a bunch of questions based on what you've told them. And that's why it's really important to be honest, because you might tell a little lie that you think makes no difference, but that lie could be a reason for USCIS to go down the rabbit hole of, oh, everything must be a lie because the person lied about this. All right. So if you have kids together, that's a good bona fide. If you're a step parent, showing that you're an emergency person with a pediatrician or with a school, that could help. But what I found is everybody's story is different. And when you put it together, right, USCIS is able to see a picture of your relationship, right? And it's also important, to be careful about, another thing I got to tell you, if you're cheating on your spouse, USCIS does not like that. So if you're out there on social media hugging men and women and just doing all kinds of manners of, immoral behavior, USCIS is going to look at that as proof that it's not a bona fide marriage, which is not true, because people can be in a bona fide marriage and they're cheating. But I'm just telling you, okay. So put your stuff together, show that you live together, you have bills together, you have life insurance, health insurance. People know you as a couple. And show up for your interview with a lawyer. Okay. So now the fourth one, I said it was extreme hardship. I think I discussed that already. If something is going on with you, and you cannot, if you're deported, it's going to be a hardship. For instance, if you have a child with the U.S. citizen, this is just an example. And of course, if they deport you, you're not going to be able to have access to that child. You're not going to be able to provide for that child. That could be a hardship. There are many hardships. Everybody's hardship can be so particular. There's some people who are from countries that are, have a lot of instability. There's war and all that. And, remember, the extreme hardship had to have happened during the conditional residency period. So, so the I-751 is that form that you don't mess around with, because a lot of people think, oh, I got a temporary green card, it's going to be really easy to get my permanent. But honestly, USCIS doubles down on those I-751 interviews. The I-751 interviews are one of the hardest interviews I attend, and USS is checking, and then naturalization, another time when they check on that marriage, if you naturalize based on marriage to a U.S. citizen, they can check on it, make sure that they got it right the first time when they give you a green card, got it right when you remove the conditions. Now you're naturalizing. Let's check again, right? So let's see. Is there anything else I need to talk about? So I think that's really it for the I-751. So let me see if I can take some questions. News View says, can a T status non-immigrants apply for gun permit in their state without an issue? News View, that's not an immigration question because I do not know anything about gun permits. I think it's state specific. So you might want to call your states and see if you can carry a gun. What are the requirements for gun ownership? Okay. So let's see. Let me go to let's go to Instagram. Now Instagram, let's see if I can read the little tiny script. All right. I'm still looking for questions on Instagram. Instagram people, no questions. All right. Okay, so Squirrel Watches says, my question is, my dad filed for me last year, but I applied for F1 visa and got denied. But my problem is I did not state on my DS that I have been filed for or have a parent there. Will that affect? Yes, because USCIS knows that your father filed for you. And when you didn't put that information, because they definitely asked that for that information and you didn't answer it truthfully, that's a misrepresentation, and that's a problem. And typically, when a parent or spouse or family member files for you in an immigrant petition, and you go ahead and apply for an F1, a lot of times it's denied because you've already declared immigrant intent with the filing, with the family immigration filing. So the F1 is always hard to get an F1 after that. But if you didn't give this information, that's misrepresentation, and misrepresentation is always a problem. Now, can it be waived? Yeah, there are waivers that could assist you, but I don't know that you're going to get an F1. Let's see. So Pigalima says, I have a question. Is there an interview after a conditional removal? Yes, a lot of times there is an interview. Sometimes, if you're lucky, they may, because we've had conditional removals where we applied and we got the green card without an interview. But that's actually not the norm. When you have an I-751 conditional removal, typically there's an interview. If it's a joint removal, then you and your spouse must come for the interview. If it's a removal based on a waiver, then you're going to have to show up. If they call you for the interview, you have to show up. Otherwise, your case is going to be denied. And if they don't call you for an interview and give you a green card, hey, congratulations, that would be awesome. All right, let's look for some more questions. All right, let me go back to so Motherland Boy says, can a DACA get married? Of course, a DACA can get married, right? If you're married to a U.S. citizen, this is the issue. If you came in, depending on the manner in which you came in, I feel like I'm gonna, excuse me. Depending on the manner in which you came in, it may be difficult for you to adjust your status as a DACA person married to a U.S. citizen. So if you came in with a visitor's visa, or you were inspected and admitted, if you marry a U.S. citizen, you can adjust your status. That's okay. However, if you came in without inspection, you're going to have to either file a waiver or find out if you're eligible to file advance parole and leave the country. And if the advance parole is approved, you leave the country. And when you come in, you're now inspected and you're now admitted, and you can now adjust your status. All right. So Elizabeth says, I have a baby for my fiance and we aren't married yet because my divorce case isn't settled yet, as my ex is delaying. We've been separated since 2019. Will I have issues when filing a marriage-based green card? So I think what I'm understanding is you're engaged to a US citizen, but you're still in the process of a divorce. I don't know that you really have an issue, but if USS is, if the baby is your US citizen fiance's, that's a bona fide, the fact that you got pregnant while you were still married to somebody else, well, I haven't heard that. I have never heard that to be a reason to deny somebody. So, but I think if you're concerned, you should really get a lawyer and make sure that they look through your case to make sure there's no issue. But having a baby for your US citizen fiance while your divorce is pending is not a reason for them not to give you approve your case, okay? Unless there's other things going on. So Emmanuel Abimbolu says, this is a good analysis. How can I schedule a consultation with you from Texas? Emmanuel, just call 973-993-1900, and or you can go to my website, www.odunlamilaw.com, and you can self-schedule. Now, if you self-schedule and you have a date way in the future, you can make the payment for the consultation and then call the office, and we can see if we can squeeze you into something closer, okay? Origo Misan says, what does it mean when they say correspondence has been received in a VAWA case? Well, correspondence was received. They received something. All right. So Chinwe says, my mom was here in 2003, but overstayed because I didn't know they reduced her visa from 2 years to 2 months. Will she be able to come again? It's been 21 years. Well, she can try, but it will be helpful if you're a US citizen. If you're a US citizen, why don't you file for her? And because if she overstayed and you're not a US citizen, that means that she has an immigration history that shows that she's overstayed. They may not want to give it to her. However, when you apply for a B1, B2 visa, you're looking to show that you're not, you're going to go to the United States and come back. If you have history that you've gone and you haven't come back when you said you would come back, then that might be a history that they want to consider. But does that mean that they won't give it to her? She has to show that, she has ties to her country and that she's not going to go and overstay. But if you're a US citizen, you can definitely file for her, okay? That would be one way to get her here. So somebody says, hi, it has been 1 year after I submitted my biometrics and I have not been scheduled for a citizenship interview yet. Wow, that's not normal, because they're really pushing fast at those interviews, because it's an election year. So they're really trying to get people to naturalize. So I think it might be a good idea to do an e-inquiry, and ask them what's going on, because that's not really normal to be waiting for a naturalization interview in this year anyway. It used to be normal for a year in the past years, but not this year. They're really moving fast on those interviews. All right, so let's see. So Enyo Oil says, how can someone that has been deported from the US through a criminal offense re-enter USA? So Enyo, that's a really loaded question. So this is the thing. If somebody has been deported, right, whether they can come back to the United States depends on the reason for the deportation. If it's a drug felony, nope, that's not happening. If it's a crime, then there has to be an analysis of the crime to see whether there's a waiver available for it. And it's really, for you to get somebody back in, typically you have a family member who's trying to file for the person to come back in, and then we'll figure out what waivers can be used to allow them to return. But the fact that somebody has been deported does not mean they can't come back to the United States, but it's very, very, very case specific. So you would really want to talk to a lawyer to see so that they can go over what the crime was, whether it was an aggravated felony, whether it was a drug felony, whether there are waivers available for that person. Okay. All right. Best of luck. All right. So. I am Nana says, if you mail your green card to USCIS, how long will it take for them to start reviewing your case? I do not know, but look at the case processing website and see how long it's taking them to adjudicate those cases. That might help. Okay. All right. So, okay, guys, I think that's pretty much it. So yes, if you know somebody who is who has their 2-year green card and their relationship is not working out anymore, right? Forward this video to them. Really, it sometimes is not as complicated as we make it. And knowledge is power. So empower yourself with knowledge so that you can get your permanent green card and move forward towards hopefully becoming a U.S. citizen. Okay. Take care, guys. I'll be back again hopefully next week, and we'll talk on another subject. In the meantime, if there's something you want me to discuss, feel free to put it in the comments. I'll review it, and that could be the topic of another conversation. All right. Take care. Bye-bye.